Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, in the post-Bruen world that we live in now, we know that many courts and attorneys in general have been doing a little bit of soul searching, a little revisiting of some of our old case law, a little re-examining of some of our statutes to see, like, do these really stand constitutional muster now that we've clarified what that test really is? One of the areas that we are seeing a whole new relitigation on is areas in which individuals have lost their firearms due to incidents that aren't violent or don't create dangerous situations. We're going to talk about a case today, a case that I think has the potential to be really, really big depending on where this goes. So today, let me get you all educated and let's talk about the case that could change the Second Amendment forever. Okay, here's the case we're talking about today. It's called Williams v. Garland, and it's filed in the United States District Court for Pennsylvania in the Eastern District. Mr. Williams was many years ago arrested for a DUI. He went through some kind of a pretrial diversion program that is unique to the state of Pennsylvania and was able to get that matter dismissed and expunged. Unfortunately, a few years later, Mr. Williams was again arrested, this time in Philadelphia, for a DUI, and because that was his second offense, he actually faced up to 5 years in prison on that. Now, I think he was only given 2 or 3 months of house arrest. He never actually served a real day in custody. But nonetheless, he was sentenced to a crime that actually exceeded imprisonment by more than a year. What's the problem with that? Well, the problem with that is that under 18 United States Code Section 922 G1, if we are convicted of a crime in which we could be punished by more than a year of incarceration, we are now ineligible to possess a firearm. And under federal law, there may not be any coming back to that. There is ways, but we're not going to get into the restoration stuff today. When Mr. Williams, of course, tried to get a license to carry a firearm, he was told, no can do. No, you see that DUI conviction, even though nobody was injured. Okay, there was no accident, there was no injury, there was no property damage. This is a garden variety vanilla DUI. Mr. Williams had absolutely no violent offenses on his record, and there was no indication that he was a chronic drunkard or illegally addicted to some kind of substance or anything like that. And he even passed the fitness examination that was required in order for him to get permission from the state to otherwise exercise an inalienable right. Of course, Mr. Williams then sued, and away we go. That's where we sit today. Now, the Firearms Policy Coalition, who's leading the charge here, has filed for a summary judgment. This argument is not that novel of a legal argument, because let us also remember that in the Third Circuit earlier this year, there was a case called Range versus Attorney General of the United States. Now, in that case, Mr. Range had previously, as a younger guy, underreported some personal income so he could still qualify for food stamps. In whichever state that was in, that constituted a felony. He was convicted of it. Later on, he was found to be in possession of a firearm, and as a convicted felon, again under 18 United States Code Section 922 G1, he was indicted. The Third Circuit en banc panel, so a full en banc panel of the Third Circuit, has in fact dismissed that indictment. And that's really continuing a trend of other cases, some of which we've talked about on this channel. For example, United States v. Daniels. Now, that's a case in the Fifth Circuit in which Mr. Daniels, who was an occasional user of marijuana, challenged his prohibition under 18 United States Code 922 G3. And his arguments were successful in the indictment being thrown out there, in that Mr. Daniels, even though he was a user of an unlawful substance, at no time was there any allegations that he was in possession of the firearm while actually under the influence of that substance. And therefore, the Fifth Circuit found that that section of 18 United States Code 922 was in fact unconstitutional. There's a case called United States v. Alston in the Eastern District of North Carolina. Mr. Alston admitted to being a daily user of marijuana. I don't even believe cannabis is legal in the state of North Carolina. The court there threw the indictment out, again under the same reasons as in United States v. Daniels. And then, of course, there's the case of United States v. Forbes in the Northern District of Oklahoma. There, Mr. Forbes had 2 felony convictions for possession of methamphetamine and a DUI conviction. Indictment there was also thrown out. And the reason we're seeing these indictments thrown out is because under the enlightenment of Bruen now, when we go back and we take a look at all of these statutes, we have to ask ourselves, is there a historical analog going back to the time in which we ratified the Second Amendment that would show that as a society we accepted these types of restrictions? Now, unlike the cases that I've talked about today, there's also the case of United States v. Rahimi that's coming up before the United States Supreme Court next month. Now, the big difference is this. Rahimi has been accused of very serious, very dangerous, very violent behavior. In all of the cases that we're talking about today, in particular Williams v. Garland, nobody, and I mean nobody, has been accused of anything remotely close to being violent or dangerous. So the question here is, taking Rahimi aside, we'll get to that on another video, is what do all of you think about the prohibitions against individuals who are convicted of non-violent felonies? So I see this as an attorney a lot when people want to do restoration of rights. It's some old drug offenses when they were back in their 20s. It's some res burgs or taking motor vehicles when they were in their late teens. Even though they were charged as juveniles, they end up in felonies. There's a lot of felonies out there that don't constitute violence or sex offenses or things like that. Do you believe that individuals such as that should be allowed to restore their rights, or better yet, should they ever even be required to forfeit their Second Amendment rights? I have stated before when we talk about Rahimi that there is a tradition going all the way back, predating even the ratification of our Constitution, that we have disarmed individuals that society deems as dangerous. However, any of the prohibitions that we're talking about on these cases here have only been in existence for approximately the last 60 years of the United States. And as I mentioned, when we have to go back and take a look at historical analogs, there really is no such thing as innovative gun control anymore. So the case once again here is Williams v. Garland, but we need to carefully watch the Range case and the Daniels case and all the other cases I mentioned, because there is a big push right now to take a very close look at whether or not non-violent felons should ever lose their Second Amendment rights in general. I'm interested to hear what many of you may think about that. Listen, we're going to go ahead and link the case up down below so you can geek out on that. We're going to keep our eye on this. We're going to keep our eye on the Range case. We're going to have to keep our eye on all these. These cases, understand, have the ability to significantly and forever alter the Second Amendment rights of hundreds of thousands of Americans moving forward. Listen, if you got any more questions about this case or anything else related to what's left of our Second Amendment rights, you guys know how to get a hold of Washington Gun Law by now. If you don't, that's okay. That information is down there in the description box. Now, in the meantime, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.